All right, good afternoon, everyone. Welcome again to Marquette University Law School, Eckstein Hall. I'm Mike Goucher, and this is On the Issues. This is our continuing series of conversations with news and policymakers, people we like to say are doing important work in this region and beyond. Today we are joined by a successful trial attorney, a man who's been an adjunct here at Marquette University Law School, a partner in the firm Strang Bradley, and somebody who's been on television a bit in the last year or so, or the equivalent of television. It really isn't television. Dean Strang was featured prominently in the Netflix series, very popular Netflix series, Making a Murderer, and he's been good enough to join us today, so please give him a warm welcome to Marquette University Law School.
Thank you.
So a quick show of hands of people in the audience. Who saw Making a Murderer? Okay, that's pretty good. But I want to do something here. I want to make sure everybody's on the same page. But we'll lay a foundation here for our discussion today. Take us back and give us the basics of the Steven Avery story. And we'll start in the mid-1980s, where he is convicted of sexual assault and sent to prison. Start there and take us to where we are today in his case.
There was a very violent, essentially murderous rape on a beach in Manitowoc County in July 1985. Steven Avery eventually was arrested by the Manitowoc County Sheriff's Department for that rape, tried, convicted, and goes off to prison on a 32-year sentence back when we had parole, as we used to understand it. 18 years into that, on a second round of DNA testing, as that technology rapidly was improving, he was cleared. That because it was the second round of DNA testing, it came down to one remaining testable hair recovered from on the victim after she was examined. Not only did it clear him, but probably more importantly in terms of the speed of his release from prison after 18 years, it identified the actual rapist, who by that time was serving a 60-year sentence for another violent rape committed subsequent to the one for which Steven Avery mistakenly was convicted. A little bit more than 2 years after he was released in September 2003, if you move ahead 2 years and a couple of months, a 25-year-old freelance photographer disappears. Last known appointment that she kept was on the Avery salvage yard where Steven and his family lived, where Steven grew up and returned to live after his release from prison. When her burnt remains were found behind his trailer, he was arrested and charged principally with first-degree intentional homicide in Teresa Halbach's death. And that's the case on which I, along with Jerry Buting, eventually represented him. We lost. He's now serving life in prison without the possibility of parole.
That's the criminal side of this. We should also mention that there was a civil case that Steven Avery was suing after he was released from prison. He did sue Manitowoc County for damages.
And that's part of the context of the criminal case is Steven brought a federal civil rights action here in federal court in Milwaukee following his release against the Sheriff's Department and some other Manitowoc County officials for the mistaken conviction. And that case was really coming to a head when Ms. Halbach disappeared, and within a week or 8 days, Steven Avery was charged with her murder.
So the Steven Avery case, I think it's safe to say, it garnered some media attention. Let me work all the way through this. It garnered some media attention locally when it was happening and when he was exonerated, when he was set free from prison after the wrongful conviction. But it did not get a lot of national attention until Making a Murder. That's when the overwhelming attention came. If you go back to a week before Christmas, and Netflix releases this documentary, And the numbers I've seen are
Well,
that,
believe me, I remember the date.
I'm sure you remember it. 35 days, the first 35 days, 19 million people watched this series.
That's an estimate, as I understand.
Estimate, yeah, it could be more. So what was it about the Avery story that you think resonated with so many people?
I don't know. I mean, you can say all the obvious things. Well, it was a murder. There's a whodunit quality to it. The setting is sort of American Gothic. But, that would be true of a lot of other true crime depictions or documentaries, some of which take off and some of which don't take off. There's certainly something that comes close to unique about Steven Avery's story just because he's an exoneree, and within 2 years and change, he's charged with an even more serious crime. He's still the only exoneree who has subsequently been charged with, any crime anywhere near as serious as murder. And he's got the lawsuit going. There's some circumstances to his case that make it almost unique, but I still don't know that necessarily explains the sort of rapid uptake of the film or the docuseries about him. I think probably part of the explanation lies just bluntly in the fact that Netflix, I think, has sort of rethought just about everything in marketing content. And I can't take that too far because I'm not an insider with Netflix, and I think within that industry they're actually notoriously closed about what they do and viewership and all that stuff. But I think that has to be part of why this particular story caught as it did, and I don't know that anybody could explain it entirely. I will tell you that I'm convinced from my brief and not very happy dealings with the Netflix PR and marketing people right before this came out, I'm convinced that they had no idea that it would spread as rapidly and virally as it did.
I think it's safe to say for people who've seen it, it is riveting storytelling. Storytelling is very powerful. And part of the power is because you're taken behind the scenes as this case unfolds. And that means that you had to trust a couple of young, sort of unproven filmmakers who were interviewing you throughout the process of this trial. Was that a leap of faith on your part and Jerry Buting's part?
It wasn't a leap of faith. It was a series of, sort of small steps of faith. We took this very incrementally. Might not have done it at all, but for the fact that the filmmakers got there and were working on a film 3.5 months before I did. And then Jerry came in 2 weeks after I did. So, by the time I was hired to represent Mr. Avery, filmmaking was underway and had been for over 3 months. There was going to be a film. Now, what that meant or when it would be shown or where it would be distributed or in what format, nobody knew. But, there was an active effort to make a film underway when we were there. They had, to a large extent, won the trust of the Avery family and of our client. So Jerry and I, we had a choice of either participating or cooperating or not. Got encouragement from the client's family to cooperate. And didn't embrace that immediately. For all the reasons, lawyers and law students might expect, there's a huge loss of control. Inevitable in, sort of letting filmmakers into what would otherwise be, essentially private moments in trial preparation or outside the courtroom. So we took this very incrementally, and what became clear is that although these were film students, they actually weren't all that young. I mean, they were both, one of them Moira had been doing camera work and production for a number of years.
And one was an attorney, too.
And one was a lawyer. Laura Ricciardi was a lawyer, and at that time, I think, was practicing on or near Wall Street at a large firm, not terribly happy, was making a career change by going back to get a PhD in film, but still was paying the bills working as a lawyer. That actually turned out to be really helpful because, when we talked about attorney-client privilege, she's sort of like, I got it. I get it, I know
right.
What became clear is that they were bright, or very bright, actually. They never lied to us. And they also were interested in broader questions, in the frame of Brendan Dassey and Steven Avery's individual stories, but they really were interested in broader questions that appealed to Jerry and to me as well.
I want to talk about the broader questions here for a moment, because I can only imagine that this experience for you is somewhat surreal, that once this was released, that your life changed, and I also sense that you see this as an opportunity. Describe for us what the experience of having this newfound celebrity has been like and how you've tried to use it for a public good.
Well, I don't know what you would describe, how you would, celebrity doesn't seem quite right, obviously.
Fame.
And whatever it is, it's transient in the way that popular culture is. So in fact, it's visibly transient to me because this came out December 18 last year, and my life today on September 16 doesn't look like my life on December 30 or February 25th or whatever. I mean, it's been a rapidly changing process. So part of that, what's important to keep in mind is this really is temporary and not only transient, but rapidly transitory, if you will. But what it has done, undeniably, for this year, is kind of, the analogy or the way I've put this is that it's sort of like Jerry and I have been handed a microphone. And with that microphone, you can either reject it or you can accept the microphone. Now, what are you going to do with the microphone? And it seemed to me that we ought to continue to pursue the kinds of issues that caused us to cooperate, participate in the documentary in the first place. So try to talk about broader issues of administering criminal justice, try to use interest in the film to identify systemic weaknesses in any project of administering justice, and to sort of challenge people, look, if you're interested in or outraged by or fascinated by something that happened in one county in Wisconsin to two men 9 years ago, what you really need to do then is ask yourself what's happening next week in the courthouse down the street from me. Many of these issues are not isolated or confined to the experience of any, two defendants. In a criminal case, many of them, at least at a medium to high level of generality, are concerns that arise hundreds, thousands of times a week in the United States alone, and would also be replicated in any country that seeks to find facts and administer punishment to the guilty through organized criminal justice.
You made an interesting comment. It was either the final episode or the next to last episode of Making a Murderer, and you said there were a couple of things that really troubled you or concerned you. One was the unwarranted certitude on the part of those in the justice system, and the other was what you called the tragic lack of humility. What did you mean by that?
Well, exactly what I said.
Elaborate for me.
Okay. I think the professionals who fill the spots, fill the offices in our criminal justice system, and I'll sort of confine my scope here to the United States, I think all of us become quite vested, whether we are conscious of it at the time or not, but we become quite vested in defending the rightfulness and righteousness of the outcomes that our courts produce. We have the country with the highest rate of per capita incarceration by far in the world. And separately but relatedly, we also have almost the longest sentences in the world, longest among the Western democracies, certainly, and almost in the world. And, so we hand out 10 years here and 15 years here and 3 years here as if it was water to people. And the sort of horror of doing that, I think, causes judges, police officers, defense lawyers, district attorneys, probation agents to kind of invest in projecting a certain confidence about both the rightfulness of the fact-finding and the basic, weighing of circumstances and the righteousness of what we're doing overall. We sort of project that to the public and become very defensive often when a mistake is brought, is alleged, or we're confronted with a factual mistake, a legal error, some shortcoming on our part. I think it's time to get more honest with the public about just how uncertain factually many of the outcomes that our criminal justice system produces are, and just about how contestable as a legal matter or as a policy matter many sentences are, many legislative decisions that remove or enhance discretion in judges or prosecutors. All of it really quite contestable, including the actual outcome in many given cases. So that leads me to want to rethink doctrines like finality. It leads me to want to rethink a whole lot about our criminal justice system, the use of death as a penalty or a punishment. And by death, I include something like the social death sentence that is life without parole, something, a sentence that once imposed sort of embeds you like a bug in amber beyond any hope of redemption, beyond any hope of rejoining the community, and just sort of waiting the biological moment of death. After 30-some years working in this area, I'm not at all convinced, I guess, just to bring it to a close, that the actual human functionality of the system in which I participate rises to a level very often where we ought to be reaching for or aspiring to some of what we do to people.
How concerned are you about this notion that there are really two standards of justice in this country, and that this is essentially about class, about resources, about issues rather than simply justice?
Well, in this country at least, and probably everywhere, your class is inseparable from your prospects in the criminal justice system, including your prospects of ever being drawn into it at all involuntarily. Class just matters. North of 80% of all criminal defendants are too poor even to take the first step of hiring a lawyer to defend themselves, let alone posting bail, paying for defense investigation, paying for defense testing or consultants, carrying all the other costs of defending themselves. It's so rare that a person of high wealth and high social status gets drawn into the criminal justice system, again, involuntarily as a defendant at all, that it makes news every time it happens. I mean, we all can name Martha Stewart and O.J. Simpson and Dennis Kozlowski and, Bill Cosby, poor Bill Cosby right now. We can name these people. That's how rare it is. When in fact 20 million Americans a year are charged with some sort of crime in our courts. 40% of that is traffic, relatively minor traffic offenses, but you're still talking about, about 12 million people a year facing criminal charges in this country.
So you are, along with Jerry Buting, you've been traveling around the country in a conversation about a lot of these issues. Mm-hmm. Is America ready for that conversation? Do you sense that audiences want to hear about the things that you're talking about today?
Well, the audiences that come to see us, which have been, in American cities, have been as small as 500 or 600 people and as large as 2,100, are self-selected. Mm-hmm. They're self-selected, and really, I think, what most of them are hoping for is some director's cut of Making a Murderer, behind the scenes. The percentage in the audience of people who've seen Making a Murderer, is probably higher than the 85% or so here. So I don't know, but what I can tell you is of those audiences that selected themselves to come here, two middle-aged white guys sit on a stage and talk about criminal justice. The reception has been warm, enthusiastic. The questions have been often very searching. Probably those talks, 2/3 or more of the conversation is driven by audience questions. So that's been encouraging. And I have to say, especially, I've been encouraged by millennials, Gen Y, Gen Z, millennials. I've got a very different perspective on people under 30 or 35 today than I did even a year ago.
So let's go to the director's cut now, because I'm sure there are a few people here interested in what's happening with the case. And I want to spend some time on what's happened since Making a Murderer, because there have been a number of developments, and maybe we can talk about a few of them. You're no longer representing Steven Avery.
No, and haven't formally represented him since June of 2007.
In some respects, do you wish you still were? Do you think there was any unfinished business for you in that case?
There's enormous unfinished business in that case for me. That doesn't mean I wish I had continued to represent him. Because as many of the people in the room know, in Wisconsin, ordinarily, if you want to raise ineffective assistance of trial counsel, you've got to do that on your direct appeal. Mm-hmm. So the responsible thing for trial lawyers to do in most sharply contested and long litigated cases in Wisconsin is to step aside and let new appellate counsel come in and take a fresh look at us along with every other possible issue to be raised on direct appeal. So I don't regret getting out. In that sense, it was the right thing to do. And, it's been good to stay in touch with Steven Avery, as we had, Jerry and I both had, until he retained Kathleen Zellner. But I don't know that my unfinished business with that case would be finished by representing him in post-conviction efforts, in part because my own role and possible mistakes at the trial are inextricable from seeking post-conviction relief, or at least considering what possible post-conviction relief might be available.
So Kathleen Zellner, Steven Avery's new attorney, has filed a motion. She wants a lot more scientific testing, forensic testing. She thinks that will ultimately prove his innocence in this case. Do you see potential, based on what you know about this case? Is there potential in her pursuing that path?
Well, where I'm certain there's potential, okay, at least for learning, maybe coming closer to the truth, wherever that lies, is that scientists can do things now that they couldn't do in 2007.
It was a frustration for you, wasn't it, that trial?
Well, I mean, we didn't know what 10 years would bring. And so at the time, we weren't thinking about the limits or limitations of science. What we were thinking about were the limitations of time, access to evidence, money, much more pedestrian sort of things. But in fact, in the 10 years or so that have passed, science really has advanced. And maybe the most potentially exciting piece of that is that it is now possible, and don't quiz me on this because, this isn't my area, but I'm not a geneticist, but it is now possible, as I understand, I've been told repeatedly, essentially to age DNA. To say, okay, this is a sample of Mike Goucher's blood, and this also is a sample of Mike Goucher's blood, but this sample is about 4.5 years older than this sample, just by looking at DNA and also the RNA. And so that's potentially, potentially very helpful here, at least broadly, in terms of getting at the truth. Because there was the dispute in this trial about whether the blood that was found, Mr. Avery's blood that was found in Teresa Halbach's Toyota, was from the 1996 blood sample that remained in a vial in the Manitowoc County Clerk of Court's office, or whether it was because Steven Avery killed her, was in the car, and was bleeding, near the ignition in fall of 2005. It now may well be possible to retest the swabs from that car and to say that they are or are not of the same age as the 9 or 10 year older sample of his blood from the clerk's office. So that's something that potentially could advance us a long way in either establishing that the blood was put there by somebody who wanted to do harm to Steven Avery, or that was him bleeding fresh at the time, and that, because there's no probable way the police would have had access to his 2005 blood.
Kathleen Zellner says she believes this testing will prove that Steven Avery is innocent. After thinking about this for a while, and I'm sure you still think a lot about it, do you think he's innocent, or do you just think it wasn't proven beyond a reasonable doubt that he was guilty?
I personally, which doesn't matter a whit, by the way, this is of no value, I personally always have suspected he was innocent. Never been certain of that. I can't be certain of that. I'd be posturing if I claimed certainty about that. But if you're asking me, I've always thought he probably was innocent. I'm much more confident then, and it hasn't changed much over time, that I shouldn't have lost the case, that the prosecution didn't meet, the requirements, the stated requirements of our legal system of proving guilt beyond a reasonable doubt. Even there, I can't be confident entirely that I'm being objective about that and fair, but I've been a defense lawyer long enough to know which cases are winnable and which are not. This was winnable, and at least, on the evidence, and I lost.
When you look back on the case, any particular source of frustration that just really stays with you? There were certain things you weren't able to do in the courtroom. A list of alternate suspects was not allowed. What kind of stays with you in terms of, boy, I wish we would have been able to do this?
Well, you identified one, offering alternate suspects. I can't, as a lawyer, I can't explain or justify the asymmetry now in Wisconsin law that the trial judge introduced and that the Wisconsin Court of Appeals adopted. The asymmetry being that the prosecution, which bears, of course, the burden of proving guilt, never has to prove motive of the defendant in a murder case. Do not have to prove motive. Have to prove you intended to kill and that you in fact killed, but you don't have to prove why if you're the prosecution, or the motive, the reason. But the defense, if it wants to offer an alternate suspect in service of reasonable doubt about whether the police got the right guy, the defense now does have to prove motive of the alternate suspect. And that asymmetry, still seems to me wrong or mistaken to the point of perverse, in the sense that it makes the admissibility of alternate suspect evidence turn on the character of the victim, if you think about it. That is, somebody like Teresa Halbach, who, as far as I know, had never done anything wrong to anyone in her life. She wasn't a drug dealer who was, cutting the cocaine. She wasn't failing to pay gambling debts. There was nobody on the face of this earth who had any reason to kill Teresa Halbach. Nobody, as far as I know. But somebody did. And when you have a blameless victim like that, you can never prove motive, because there is no rational motive to kill this young woman. If you happen instead to have a very different victim, somebody with a very checkered past, or somebody who's going through a contentious divorce or whatever, any number of people might have had a reason to want dead. Now the alternate suspect will be available to you as the defense. And the problem is that the character of the victim has not a thing to do with the potential innocence of the defendant. It's logically disconnected from that, and yet the trial, the availability of that defense can turn, and does turn now, on that sort of, to me, non sequitur of can you or can you not prove motive.
You are not Brendan Dassey's attorney, but as people in this room know, who are familiar with the series, Brendan Dassey was also convicted in connection with Teresa Halbach's murder. He was 17 years old at the time. Recently, a federal judge said, I'm going to overturn that conviction. I think his confession was coerced. I'd like to get your reaction to the federal judge's decision, and then I'd like to get your reaction to the decision by the state of Wisconsin to continue to pursue this case.
Whether you agree with Judge Duffin's decision or not, I think what fairly can be said about it is that it was a thorough, thoughtful, fact-laden, and really very careful decision. Whether he came to the right or the wrong conclusion, I think all of those things are true about it. It was good judicial handiwork by any measure, I thought. And I'm not surprised at all that the Attorney General's office decided to appeal it. I mean, after all, Brendan's conviction is 9 years old. Kind of comes back to the certitude and humility issues on which we started. The sort of institutional momentum to preserve the status quo becomes really powerful over time. In the institutional actors in our criminal justice system, I think, are very, very reluctant to upset status quo. And it means acknowledging a significant wrong or a mistake, which is hard. It means potentially putting a victim's family through another trial years after the original trauma of the trial. It means probably shakier prospects for conviction the second time around, both because you'd be losing a significant piece of evidence and admission, that videotaped interrogation, and because, witnesses are all human, just like the rest of us who work in the criminal justice system. So, as they say, memories fade and people disappear, and the practical problems of retrying the case, and all of this really sort of creates a hydraulic pressure to try to defend the status quo. The surprise would have been had they not appealed.
Last night at the Emmy Awards ceremony for creative arts, I believe Making a Murderer won 4 Emmys. So I don't think there's any question that it's a powerfully told story. The questions that have been raised by some are whether it's a complete story or whether it's a story that favors the defense and not the prosecution, whether things were omitted or selectively edited. Obviously, you have your own views on this case, but was the documentary everything you hoped it would be? Could it have been better? Could it have been fairer?
I honestly didn't have what I would describe as hopes for the documentary, other than that it would be, if it ever was sold and aired somewhere, I hoped that it would at least sort of address broader issues and not be a voyeuristic exploration of someone's death. And I think I think even the critics, Ken Kratz and other critics of it, don't accuse it of being tawdry or just, voyeuristic. What they do accuse it of is omitting important prosecution evidence. I don't think that's a fair critique, mostly, okay? Now, and the reason I say that is this docuseries gave over 3 hours to the Avery murder trial. It gave another hour or hour plus to the Dassey trial for the same murder, okay? That's a lot of time. I mean, 3+ hours on the Avery trial is more time than Dr. Zhivago gave the entire Russian Revolution, okay? And at the same time, you're talking about a trial that had 5 full weeks of evidence. So something like 140 hours, roughly 140 hours of evidence, a week of jury selection, several days of opening statements and closing arguments when you add them all together, 2 or 3 days of that. You can't make a 140 or 150 hour movie about a trial. At least I hope you can't. I'm not watching it. And so a lot necessarily gets left out. To my eye, with 2 possible exceptions, the filmmakers did include in the end everything that the prosecution was claiming in 2006 and 2007 was its most important stuff, and everything that the defense was claiming at the time, during and before the trial, was our most important stuff. That information, those points, are included in some fashion, with 2 possible exceptions, as I say, and they're only possible exceptions. One, on the prosecution side, the prosecution was talking about the hood latch DNA. For those of you who geeked out on Making a Murderer, you know what I'm talking about, or the following discussion of it. The hood latch DNA, they were talking about that some. Now, I think in closing argument, I think Ken Kratz gave about a half a page of transcript to that out of a 100+ page closing argument, but they were talking about that. On the defense side, a lot of the defense ended up focusing on some expert testimony from a forensic anthropologist in Canada on where the bones likely were burned and where they moved from the Avery burn pit to a couple of other places, or where they moved to the Avery burn pit. And although that expert appears very briefly in the film. You don't get a sense of what the thrust of the defense theory was. But, you know, in the end, Ken Kratz can go make his own damn movie, and Dean Strang can make his own movie. You know, I mean, neither one of us were these filmmakers. Neither one of us couch surfed for 8 or 9 years, you know, and tried to cobble together enough money to make this thing and then stick with it until they were able to sell it. So I'm not inclined to be too critical. I do think there's a defense cast to this, but I think the most important reason for that lies in this truth. The Avery family gave the filmmakers access. The victim's family, for perfectly understandable reasons, did not. And the police, in the end, chose not to. And the prosecution refused repeated, you know, requests to participate and cooperate. They all made their decisions, and I fully support the Halbach family's decision. I would have made the same decision in their shoes. The reality, though, was because of different access, the viewer, in the end, sees the Avery family members as three-dimensional human beings. You see them in the kitchen, you see them in the vegetable garden, you hear their anger, their frustration, their hurt. They become fully human. Without access to people on the other side, you're left with, you know, press conferences and statements in front of a bank of microphones. It's, I think, much harder, you know, to give dimensionality to and humanity, a real sense of humanity, to, let's say, the Halbach family, who I know to be extraordinarily good, lovely people, who carried themselves with enormous dignity throughout this process. I mean, enormous dignity. You know, but that's, I think, part of why this has a feel of a defense cast, just because the respective humanity of the players, the filmmakers were able to develop with the Avery family and the Dassey family, and much more constrained in developing, not through the filmmakers' choices, but through other people's choices on the prosecution and the victim's family side.
2 more quick questions. We'll take some questions from the audience. You've got a fair number of law school students in here. You just articulated, I think, one of the great challenges when you go into trial law, when you do what you do for a living. You're obviously looking out for the interests of your client. That's what you're hired to do. But there are people who are affected by what happens at a trial, the Halbach family, for instance. Even the law enforcement officers who you cast doubt on some of their testimony and their actions. How much can you think about that during the case of a trial? Does that cross your mind about what this might be doing to a family, what this could be doing to the lives of others? Is that part of the process? Frequently.
Frequently. And, you know, if you're serious about your own set of duties, and if you're aware of your set of duties, you do what duty requires. But you can almost always do that in a way that doesn't rob someone else of their dignity or their humanity. I mean, you can. In fact, not almost always. You always can. Now, if somebody wants to get up on the witness stand and lie, you know, I'll take that. But they're surrendering their dignity. I'm not taking it from them. If they're up there lying or evading, you know, or posturing as something they're not. Yeah, so I mean, you do think of it. The police officers, I think of that too, because you get to know them a little bit. You may already know them if it's a locale in which you regularly practice. But you know, they at least are voluntary participants in all of this. I mean, they signed up, in a sense, to participate in work in the criminal justice system in the same way I did. And victims and victims' family members do not. They are conscripted. You know, the idea of having to sit in a courtroom for weeks on end and sit through days in which lawyers are passing around a white cardboard box containing your daughter's remains, her charred bone fragments. If that doesn't cause you to think, you're a lost cause. You don't have much humanity if you're not aware of what that means and what impact that necessary part of a trial has on some of the people sitting in your courtroom. So, there's nothing about being a lawyer that requires you to be less of a human being. In fact, I think everything about a lawyer calls you to be a better human being, to be the best human being you can be. So, you get opportunities where you get to test how well you're doing.
My final question is this. The creators of Making a Murderer say there will be more episodes. Will you be a part of any of those episodes? Have they contacted you about that?
I don't know if I'll be a part of them or not, and the reason, and that's not an evasion. Yes, they've contacted me. Yes, they came in 6 weeks ago, something like that, somewhere in the summer, and filmed Jerry and me for a short time, about an hour or something. Asked us questions that suggested to me that at least part of the focus, or maybe the entire focus, I don't know, of the next episodes will be the appellate and post-conviction process. So the questions Jerry and I were asked were at a pretty high level of generality, just very general questions, but they focused on appellate and post-conviction process. I have no idea if they'll use that or not. I wouldn't. And I also don't know, I don't know what they've got in the can, so to speak. What was filmed 9 or 10 years ago that may turn up. I'm not eager really to find out.
And there's also the possibility, at least some discussions about you doing something in a format for television about particular cases, but that's still sort of in the talking stages? Without getting into how Hollywood works.
Speaking of surreal, yeah. Right. No, there's a possible project that I like, and I hope it works, because I like the young, non-scripted TV executive who came up with the idea that would entail me being sort of a guide or a host on The Road to Justice, is the name of the show, where we would examine contemporary possible miscarriages of justice, either possible wrongful convictions or possible wrongful acquittals. And if this happens at all, each episode would focus on one of those. They would be filmed sort of on site in the milieu of the crime, and there would be a through line in each season of an historical miscarriage of justice that, raised systemic weaknesses, and the viewer would be able to see, how far have we come on dealing with race, or money, or, forensic evidence, whatever it might be. How far have we come or not come? So we'll see. There's 10 reasons that may never happen.
We'll wait and see. We're going to take a few questions from the audience. Those of you in the seating bowl, especially our students, know how this works. Press down on the rim, not on the ball, but on the rim. Keep your finger down. We'll be able to hear all the questions. If you're in the back, look for Ryan. Ryan has a microphone. He'll hold the microphone as you ask your question. And again, no speeches. If you could just be brief, we'll try and get to maybe 3 or 4 questions. Frank, go ahead.
Dean, one of the things that you mentioned in the beginning was the enormous disparity there is in our justice system depending upon the economic, social class of a defendant. Lower class defendants don't get Johnny Cochran. They don't get even Dean Strang usually. What we saw in the Making of a Murderer was a poor, vulnerable boy that gets a public defender, a lawyer though, sworn to uphold the importance of being able to defend your client, who then turns him over completely turns them over to the police, has them confess, and doesn't even defend them. In this whole process, have you given thought, and I'm sure you have, but have you heard feedback from people that suggests some ways that we might be able to furnish those people, innocent people, who are otherwise going to be convicted because they can't afford or can't have access to not lawyer or even a competent lawyer? In this whole process, is that one of the things that you have thought about, one of the issues that has been discussed when you've gone around the country?
Yes, Frank, yes. And I mean, let me quibble but it's an important quibble. The lawyers assigned to Brendan Dassey were not public defenders in the sense of being state public defender staff attorneys. They were lawyers who agreed to take court-appointed cases. And yes, I've thought about that, and I'll tell you, let's be blunt. It's not just about defending the innocent. It's about defending the guilty and mitigating, making the system work as it should. I've talked a lot about where we might start. We might start by saying, the $40 an hour we pay court-appointed counsel in the state hasn't gone up since 1978. Not one nickel has it gone up since 1978. And at a time where even a bare bones, small law practice costs, on average, if you look at the state bar, something 48, 50, 55, whatever the number is now, dollars per hour just to open the door and turn on the lights. That's just the overhead for a bare bones law practice on average. What is $40 an hour buy you? And why are we asking criminal defense lawyers, or those who hold them out that way, and them alone, in effect, to subsidize the prosecution of their own clients by working at a loss on their own overhead, let alone anything they might want to pay themselves? I did the numbers on my firm, 4 lawyers, 2 assistants, offices in Madison, which is, high rent compared to Milwaukee even. But we're at nearly $200 an hour to turn the lights on, spread across a 40-hour week. I'm going to take a case for $40 an hour and, in effect, write a check for $160 an hour for every hour I work on behalf of an indigent defendant? No, I'm not. So when I take an indigent defendant, I'm just doing it for free, okay? Because $40 an hour is an insult, not just to lawyers, but to the citizens in whose name we prosecute people. And you do get a sense, I think, maybe in this film, of what $40 an hour gets you in the marketplace. And I got to tell you, other than federal court, it's not a world better anywhere else in this country. Some states are paying $65 an hour, $70 an hour, but some states also have caps. Wisconsin doesn't put a cap on the fee. So we scandalously and deliberately underfund the defense side of criminal cases. And it is the defense side because, again, you're talking about between 80 and 90% of people charged with a crime in this country everywhere. I don't care whether it's Manitowoc County or Onondaga County, New York, or where. Everywhere, between 80 and 90% are indigent. And their lawyer is provided at taxpayer expense.
Student questions. Yes, go ahead.
That raises an excellent point, really, because here in Wisconsin we have a crisis in terms of pay progression for the prosecutor's office. I'd love to hear your thoughts on how the growing lack of experience on the prosecution side is inhibiting or presenting an obstacle for the administration of justice.
You see it every day. You really do, and I don't want to be glib about that, and I'll try to add a little color to my response. But, in Dane County, where I live now, 2 very talented prosecutors I used to run into at night at their bartending or table waiting jobs, working 2 jobs, waiting tables at night to try to pay off their student debt. One of them was a supervisor in the Dane County District Attorney's Office. He left. He went to Hennepin or Ramsey County, one of the Twin Cities, and increased his pay something like 60% by moving to the prosecutor's office up in Minnesota from here. So, I talked about the underfunding of the defense. Don't get me wrong, we don't fund the prosecution side lavishly. We underfund that too. They just do better on the whole than the defense. There's pay parity for assistant DAs and assistant state public defenders, all right? Both of them are way too low. I don't know how you come out of law school these days if your parents and your family and you are of average means. You come out with, what, $150,000 in debt, if you're lucky, after 7 years of school. I don't know how you take a $40,000 a year job and expect ever to be able to marry or buy a house or have a child. I don't know how you do it. So you have enormous turnover in the ranks of young assistant DAs. And what that means practically is that the sort of perspective that experience can bring on what's the real worth of a case? What really can we hope to accomplish with this case? Why is it okay to dump a weak case? And when should you do that? How should you view law enforcement officers? How do you learn when they're spinning you? How do you try a complex case, a case involving a lot of paper? All of that is being lost to our district attorney's office, I think to the great detriment, not just of victims, but to the administration of justice for all of us. And that's not to say, the color in this, that's not to say I want everybody in a district attorney's office to stay there forever. There's a hazard to that too, to becoming too habituated to, the courthouse. You want prosecutors and defense lawyers to be fresh and to have their eye, as much on the victims and the work they're doing and the ideal of justice as they do on their 401k plans, okay? But you cannot justify the ways in which we're, slowly starving our criminal justice system in this country, and that includes the prosecution side.
Let's take it. One more question up here. Yes? Yeah, right there.
Thank you. I'm going to turn attention a little bit away from making a murderer and ask about legal writing. As I use in my class a sentencing memorandum that you wrote in State v. Mark versus Benson from 2009, and the introduction to that is some of the most persuasive writing I've seen and compelling. And in trying to teach
I wish
students,
you'd told Judge Davis.
I'd be happy to, but I know it's a little late. I wish if you'd give us this for the students in the room, just what is it about, how did you learn to write that well, and how would you tell students to be persuasive like that?
Well, if you won't throw the microphone at me, for myself, I think appending the adjective legal in front of writing creates an impediment right at the start. It doesn't have to. We can overcome that. And I'm not just trying to make you feel better, but I do think that the teaching of legal writing has gotten dramatically better in the last 10, 15 years. Just, it's been rethought. The pedagogy of it has been rethought, much to the gain of law students. But for me, good writing is good writing, and it doesn't need the adjective in front of it. Yes, we live in a world where cases matter, and a comparison of case A to case B, and is case C more like A than B, matters. But in the end, any writing that's good has an audience in mind and thinks through, how do I communicate most clearly and most powerfully to that audience? how do I strip out the unnecessary, clear the fog, and try to persuade or communicate most forthrightly, sincerely, and directly with that audience, because persuasion lies in sincerity. I think it just does. And in clarity of thinking communicated through clear writing.
I'm going to have to wrap things up there. Before we go, just wanted to mention one thing. Our next event in the On the Issue series is this Wednesday. Professor Kathy Kramer from UW-Madison will be here. She's written a great book called The Politics of Resentment. She went around the state talking to people, especially in the northern part of the state and the western part of the state, about how they feel about the way things are, and it's, I think, an especially timely conversation given this year's presidential election. I want to say thank you to everyone who was here today for your interest, your attention. We hope you'll come back. And again, our great thanks to Dean Strang for being with us today. Dean.